Good morning, class. Today we will talk about the applicability of the Indian Evidence Act 1872. If we look into the preamble of the Evidence Act, we find that it mentions the Evidence Act as an act to consolidate, define, and amend the law of evidence. It means that the 1872 Act was enacted to consolidate and amend the laws of evidence, the rules of evidence that were applicable in India prior to 1872. By mentioning the term consolidate the law of evidence, the preamble has made it clear that this is the exhaustive law that deals with evidence. However, despite the fact that this is a consolidating law, it does not carry all the rules of evidence. I mean to say, if we look into other statutes like CRPC, that is the Criminal Procedure Code 1973, or to the Civil Procedure Code, we find mention about certain rules of evidence. If we look into section 162 of CRPC, it mentions an exclusionary rule of evidence which says that the statements made by any person to police officer during the course of investigation are barred from being used in the court of law. Similarly, if we look into section 306 and 307 of Criminal Procedure Code, it permits the magistrate to tender pardon to an accomplice for getting true and full disclosure of facts. This, I believe, is an exception to Section 24 of the Indian Evidence Act, which bars confession made under inducement, threat, or promise proceeding from a person in authority. Also, if we look into Chapter 23 of the Criminal Procedure Code, we find that evidence, there is an entire chapter on titled Evidence in Inquiries and Trials. Similarly, if we look into Civil Procedure Code, in Order 12, there is a provision relating to admissions. Order number 18 mentions about hearing of the suit and examination of witness. And there are other provisions also which directly or indirectly relate to evidence. However, we may find that there are certain rules of evidence mentioned in different statutes, but Evidence Act is a complete code in itself, and no judge can override the mandatory provisions of the Evidence Act and admit evidence not admissible under the statute. Further, if we look into section 1 of the Indian Evidence Act, which talks about the short title extent in the commencement, it mentions that the Indian Evidence Act extends to the whole of India, to all the judicial proceedings before any court, including court martials. However, excludes its applicability on the Army Act, the Naval Discipline Act, the Indian Discipline Act 1934, and the Air Force Act, besides affidavits and proceedings before an arbitrator. Now, let us try to explore the territorial applicability of the statute The term territory is derived from a Latin term terra, which means land. However, for the purpose of law, we give a three-dimensional definition to the term land by including water, bodies, rivers, and aerospace. Otherwise, if we exclude these terms, airspace and water bodies, the purpose of the statute would be defeated. Besides, Article 1 of the Indian Constitution defines India, that is Bharat, shall be a union of states. The names of these states and the union territories are mentioned in the Schedule 1 of the Indian Constitution, which also includes the territories that may be acquired from time to time. Like we have examples of liberation of Goa, Daman and Diu, merger of Sikkim, and the exchange of borders, certain enclaves with the East Pakistan, the Berubari exchange under the Noon Pact of 1958. Moving further, the definition or the provision in section 1 mentions that the Evidence Act is applicable to all judicial proceedings before any court of law. The term judicial proceedings is not defined in the Evidence Act. However, we may refer to section 2, clause 1 of Criminal Procedure Code, which defines, I'll read, it says, judicial proceedings includes any proceedings in the course of which evidence is or may be legally taken on oath. Here in this definition, the test is whether the body conducting the proceeding is authorized by law to receive evidence and decide on the basis of that evidence. However, the power to receive evidence cannot be said to be the sole criteria for determining the definition of judicial proceedings. There are certain other things that we need to look into, and one of those things could be the purpose is to establish the dual relation between the parties, the litigating parties before the court of law. In the previous video, we referred to the substantive law. Substantive law confers on the people their rights, their liabilities, their powers, and their duties and responsibilities, wherein a judicial proceeding is such where these rights, liabilities, duties, powers, and responsibilities are established by the court. Another important test could be whether the decision making process by the body involves the application of a judicial mind or judicial discretion, which is guided by the evidences which are adduced or produced before the court by the bodies or the parties. These three tests that I have just mentioned distinguishes between the judicial proceedings and the fact-finding bodies or the administrative bodies. These fact-finding bodies only collect the facts, and their outcome depends on the facts which are discovered by the body, and that is obviously not the outcome of any kind of discretion. These administrative bodies or the fact-finding committees, they take evidences, they collect evidences, but only for the purpose of ascertaining the true fact. They do not exercise their own discretion to come to any final result. The proceedings before these bodies may have certain tappings of a court, but they cannot be counted within the definition of or within the ambit of judicial proceedings. The Indian Evidence Act is also applicable to the court martials convened under the Indian Army Act 1950, the Indian Air Force Act 1950, and the Navy Act 1957, which were enacted by the Indian Parliament after independence. And if you look into the provision of Section 1 as contained in the Indian Evidence Act of 1872, we find there is a mention of Army Act, Navy Discipline Act, Indian Navy Discipline Act 1934, and the Air Force Act. These are the acts governed under, these are the acts under of the United Kingdom, and the court martial set up under those acts are not governed by the Indian Evidence Act, which is why they are excluded specifically under Section 1 of the Indian Evidence Act. While Section 1 makes it clear that the Indian Evidence Act is applicable to the court martials which are convened otherwise, like I mentioned, the Indian Army Act 1950, the Indian Air Force Act 1950, and the Navy Act 1957. The Indian Evidence Act also does not apply to the proceedings before an arbitrator. The Act does not distinguish between between statutory arbitrations and private arbitrations. Statutory arbitrations like Section 10 of the Industrial Disputes Act 1947, or private arbitrations under the Arbitration and Conciliation Act of 1996. If we look into Section 19 of the 1996 Arbitration and Conciliation Act, it mentions specifically that the arbitral tribunal constituted under the Act shall not be bound by the Code of Civil Procedure 1908 or the Indian Evidence Act 1872. Clause 2 of Section 19 also mentions that the parties to the arbitration are free to determine their own procedure, and in the absence thereof, the arbitral tribunal may conduct the proceedings in the manner it considers appropriate. Also, if we look into Section 89 of the Civil Procedure Code, it provides for the settlement of disputes by arbitration by reference by the court. Clause 2A provides that these arbitration proceedings shall be deemed to be proceedings under the Arbitration and Conciliation Act of 1996. Thus, it means that even the arbitration proceedings under the Civil Procedure Code Section 89 are also not governed by the Indian Evidence Act. Besides, affidavits are also excluded from the applicability of the Indian Evidence Act. An affidavit is a sworn statement made by a person as to the truth of the facts within his own knowledge. Thus, the Indian Evidence Act is not applicable to affidavits as well. Thank you.